All right, let's dive in. Today, we're unpacking a really fascinating legal showdown. We're talking about a law that was literally designed to stop profiteers during the Civil War, but is now somehow at the very center of a modern battle over the powers of the U.S. government.
So yeah, you've got to be asking yourself, how on earth does a law that's that old cause such a stir in the 21st century? It's a fantastic question, and trust me, the answer is probably not what you're thinking. To really get it, we've got to go back, way back.
So, first things first, let's meet the law at the heart of this whole conflict. It's a piece of legislation that was born out of a massive national crisis, and its original job was, well, absolutely critical. The law at the center of this whole storm is called the False Claims Act, or the FCA for short. It was passed way back in 1863, right in the middle of the Civil War. And its purpose was pretty simple, to stop shady profiteers from ripping off the Union Army. And the fraud back then was just blatant. Picture this. You've got these sketchy contractors selling the Union Army the same horse twice. Or even worse, delivering crates of sawdust and calling it gunpowder. The False Claims Act was created to put a stop to exactly that kind of thing. So how does a Civil War law about horses and sawdust even apply today? Well, it's evolved a lot. It's transformed into an incredibly powerful tool for modern-day whistleblowers. The way the modern law works is through something called a qui tam provision. Now, that's a Latin phrase, but the idea behind it is actually pretty straightforward. It gives a private citizen, a whistleblower, the power to sue someone on behalf of the government when they find fraud. They basically get to be a private watchdog for our taxpayer money. And this whole idea is ancient. Really ancient. As you can see here, its roots go all the way from early English common law to the very first U.S. Congress back in 1789. It was then forged into the False Claims Act during the Civil War, and then, get this, it was supercharged in 1986 to fight fraud from defense contractors. So yeah, this is a legal tradition with centuries of history behind it. But just because something has deep roots doesn't mean it's not controversial. And today, this very old law has created a huge constitutional tug-of-war between the different branches of our government. And this gets us to the heart of the conflict. When a whistleblower brings a lawsuit, but the government itself wants to dismiss the case, who gets the final say? The government or the courts? This single question has completely split the federal courts across the country, which means it's pretty much up to the Supreme Court to lay down the law. So you've got two really clear sides here. On one hand, the Department of Justice argues it has absolute authority. They say, look, we're the executive branch. We get to decide if a case is a waste of resources or not in the public interest, and that's that. But then you've got courts pushing back, saying, whoa, not so fast. We have a duty to review that decision to make sure it's actually rational and fair, especially to the whistleblower who's risking everything to bring this forward. And let's be clear, this isn't just some technical legal squabble. This cuts right to the very core of our constitutional structure, the separation of powers. It forces us to ask some really fundamental questions about the roles of the president in the courts. Just think about it for a second. Who is the real prosecutor here? Is it the government, the official authority, or is it the private citizen, who the law itself empowers to bring the case? And that leads to the next question. Who's really in the driver's seat? Does the executive branch get to call all the shots in the lawsuit, or does the whistleblower, the relator, have some independent right to keep going? And finally, what's the judiciary's proper role in all this? Should a judge just rubber stamp whatever the government decides, or should they act as a check on that power and oversee the decision? The Supreme Court's answer here is going to define this balance of power for a long, long time. Okay, so this constitutional debate has massive real-world consequences. The Supreme Court's decision is going to have a direct, tangible impact on whistleblowers, on giant corporations, and on the government itself. Let's just break this down. For whistleblowers, what's at stake is their very power to see a case all the way through. For the government, it's all about control over its own litigation and executive power. For corporations, especially huge ones in defense and healthcare, it could mean a lot more or a lot less exposure to these expensive fraud lawsuits. And for the courts, it's about defining the very limits of their own authority. So, with the stakes this high, what's next? Well, all the signs are pointing in one direction, the Supreme Court stepping in to settle this once and for all. You see, if there's one thing the Supreme Court likes to do, it's resolve what's called a circuit split. That's just a fancy way of saying different federal courts are applying the same law in different ways. They want one single rule for the whole country. And on top of that, several justices have already put it in writing that they are ready and eager to tackle this exact issue. So, based on all those signals, legal experts think it's very, very likely the Supreme Court will hear a case on this, possibly in their 2026 to 2027 term. A final answer is definitely on the horizon. And that leaves us with the ultimate question, doesn't it? The one at the heart of this entire explainer. When a private citizen stands up to expose fraud that's being committed against all of us, but the government disagrees with how they're doing it, who gets the final word? The executive branch, the courts, or the citizen themselves? It's a question that's as old as our country, and it looks like we're finally about to get a modern answer.